These matters, Your Worship, were earlier clubbed together. Item 12, 13, and 14.
Yes.
But subsequently, since item 12 was segregated by the trial court by giving it a separate case number, and a separate judgment was also passed by the trial court. So a separate paper book has been prepared for item 12, which has recently been furnished to us. So instead of clubbing these three matters together, my humble prayer, Your Lordship, is that item 12 be segregated from item 13 and 14.
Yes. What do you say?
Yes, my lord.
You are also PP?
Yes, my lord. I'm on behalf of item number 12.
Then when do you want
After the vacation, Your Lordship?
all these three cases?
Yes, but 12 may be segregated from 13 and 14.
Please write down item 12. Mr. Oh, this is a common order, okay? 12 to 14. Mr. A.R. Malhotra, learned counsel appearing for the appellants in Criminal Appeal 9 of 2022 and Criminal Appeal 10 of 2022, submits that Criminal Appeal number 1 of 2023 may be segregated, since the learned trial court has passed a separate judgment and a separate paper book has also been prepared. Stop the said submission is agreed to by Miss
Vane Siami.
Vane Siami, learned additional PP,
Yes, my lord.
appearing for the state. In view of above, let Criminal Appeal number 1 of 2023 be segregated from the other two cases. Next para, list these matters. Again, after the ensuing puja vacation, as paid for.
I'm open.
See, one copy each of this order will go in all the cases. Okay?
May I please, Lordship?
Yes?
Lordship, with the consent of the respondent, Lordship, I beg to mention item number 1, Lordship, for adjournment, Lordship, for today.
Why do you want adjournment?
Lordship, my senior is leading this matter, Lordship.
Sorry?
My senior is leading this matter, Lordship. He is having difficulty to appear today, Lordship.
He's having difficulty.
Difficulty to appear, Lordship.
So when will he be able to appear?
Lordship, after vacation, Lordship.
And you want a date also?
Lordship, as you have convenient.
Yes. Who's for the other side? Government advocates have not come. Ms. Zairam Sankwi has come.
Lordship, I'm appearing for the state respondents in this matter. Item number
What do
1.
you say? They want adjournment.
Lordship, I have no objection, Lordship.
Ms. Zairam Sankwi, item 1. They want it after the vacation.
Yes, my lord. I have to find my affidavit also, my lord.
You have not filed?
Yes, my lord.
When are you filing it?
Because after 4-month notice has been issued to the respondent number 2, it's only that hard time of listing, my lord.
Okay. Mr. B. Chakma, learned counsel, submits that he is led by Mr. S. Borogain in the matter. And since he has some personal difficulties to appear before the court today, he prays that the matter be listed again after the ensuing puja vacation. Stop the said praise not objected to by the learned government advocate as well as Ms. Zairam Sankwi, learned CGC. Stop the learned CGC also prays for further 3 weeks' time
Yes, my lord.
to file counter affidavit. Next para, in view of above, list the matter again after the ensuing puja vacation on a date to be fixed by the registry.
Humbly obliged.
Yes.
Obliged.
Lordship, item number 11 is hearing. This may be taken up tomorrow if there's availability of time.
Tomorrow may be difficult because we have division bench.
Right. Thursday, Lordship, I have some personal problem. If it can be taken up on Friday. We have fixed one other matter on Friday.
No,
It's in the admission stage.
can I have it on Monday?
Monday.
Monday.
All right, all right. God bless.
Right like this. And the prayer of Mr. Sila Ramzao, learned senior counsel appearing for the appellant, and not objected to by the other side. List the matter again on Monday. Next. Please give the date for hearing.
If I may seek your lordship indulgence, I'm mentioning on behalf of Miss Mary regarding item 11, item 10. She has some difficulty, and if she prays that the matter may be fixed at the convenience of the court, your lordship. She has some difficulty today.
What is the matter regarding?
This is a POXO matter, your lordship, and there are several evidence that has to be appreciated, looked into.
Okay. After the vacation,
Apply.
as prayed for on behalf of Miss Mary L. Kianta, learned additional PP, appearing for the state and not unobjected to by the learned amicus curiae. List the matter for hearing again after the ensuing vacation on a date to be fixed by the registry.
For orders, item number 9.
May I please, Your Lordship?
Yes.
Lordship, this is an application filed by the state. The state has filed an appeal. However, there is a delay of 596 days in filing the connected appeal. Lordship, the reasons being is that there was no culpable negligence or carelessness on the part of the applicants. It was due to the unavoidable circumstances and bona fide reasons, Lordship. The reasons I've mentioned it in my application, Lordship.
Just a minute, okay? Okay, so the appeal sought to be filed is against judgment in civil suit 95 of 2011.
Yes, Your Lordship. Civil suit 95 of 2011, and the judgment and order date is 31/1/2022.
31C, not 1.
31/3/2022.
Then
And the
where is
senior
your,
civil judge,
where is your explanation?
the explanation is on page number 3 of my application, Lordship.
When was it received?
It was received by the concerned department on 6/4/2022
From whom?
from the Government Advocate District Court. Annexure is on page, annexure number 2, page 29. It was white letter 6 April 2022 and was received by the concerned department on 7/4/2022, Lordship. The
Letter is dated
letter is dated 6 April 2022, 6/4/2022, page 29.
yes.
Yes. And in Annexure 3, Lordship, this is a letter dated 20 April 2022. The judgment and order dated 31/3/2022 was again forwarded to the DFO, Darlon Forest Division, Darlon, Mizoram, by the Deputy Conservator of Forest,
What is
and
that?
has requested,
What is that? Deputy.
page number 30.
Yes, this is a letter from Deputy Conservator.
Yes, Aizol.
To?
And it was again sent to the divisional officer, forest officer, Darlon, Mizoram. The judgment and order was furnished to the DFO, Darlon Forest Division, Darlon. And here they have requested to submit parawise comments, the advice on the above mentioned judgment and order.
See, the copy of the judgment was given to the Secretary Forest and PCCF and DFO.
Yes, yes.
But this letter of 20th April is written by DCF.
Yes. Those were the parties in the lordship, uh, in the trial court also. They have received the
Okay.
judgment and order.
So Paravas comments was called for.
Paravas comments of the judgment and order was yes, they have requested to the DFO.
Then,
Then
thereafter,
on 5th May 2022,
DFO was written back.
yes,
Yes.
to the principal conservator of forests, they have
Okay.
sent it back. But however, lordship, on 5th May, this was again forwarded to the DFO 7/6/2022
No, no.
to the
You come to Annexure 5. What is the explanation to Annexure 5?
to the
DFO wrote to PCCF supplying
Yes.
the Paravas comments. Then,
and the DFO has written it back and submitted the Paravas comments of the judgment in order.
To the
But
government.
however, lordship, this was
no. You complete the
yes,
sequence.
this was
Please complete the sequence.
yes,
PCCF has in turn written to the government on 18/5/2022. Correct?
yes,
Annexure
Yes.
5, page 32. Then,
yes. They have furnished the Paravas comments.
not only that, it says that I am to request you to file an appeal
Yes.
against the order of so and so. So,
But
appeal,
however, lordship, on in the next page, Annexure 6, that is dated 26 May 2022.
yes.
The annexure required are not attached in the Paravas comments, so they have requested again to furnish all the annexures and the supporting documents.
Annexures not attached.
Yes.
Then,
Then on 7 June 2022, this Deputy Conservator of Forests has again requested the DFO, Darlon, to furnish the annexure.
so DFO also did not have the annexure.
Yes.
So, without annexure, it just simply forwarded.
The
What did he
DFO
forward?
Yes, might be, lordship. Yes, it might be. So they have asked for the annexure from the DFO again. And on 9 September 2022, there's a long gap between this, lordship. But however, I have explained it in my application that during the month of June 2022 and August 2022, the DFO, Darlon Forest Division, was attending to some urgent court matters. So in his division, so there was some delay in refurnishing the Paravas comments.
Where is that?
So on 9 September,
Where is your statement?
statement is on page number 4, Roman number 4.
June to August, June, July, August.
Yes.
But what are those urgent matters?
Lordship, that I'm not aware of at this stage, Lordship, but this is just the reasons which have been supplied to me.
For which
Yes.
he could not attend to this
Yeah.
supplying of annexures
Yes.
between June to August.
Yes, it is, Lordship. So again, on 9/9/2022, the DFO resubmitted the Paravas comments. It is on page 35.
Who submitted? DFO.
DFO. The DFO submitted to the Principal Chief Conservator of Forest, PCCF.
Now you come to this letter at page 35.
Yes.
Subject is there, then reference is there.
Yes,
What is this reference letter? 29/8/2022.
29/8/2022.
What is this letter?
Lordship, I have not been supplied a copy of this letter. It might be some.
You cannot say that, Miss Learned Government Advocate, that I don't have this copy, I don't have that copy. That means you are not properly instructed. See, I don't have to say all these things. The opposite party will point out all this lacuna. How do you intend to answer that?
Lordship, I can get the copy of the letter by filing an additional affidavit if your Lordship permits me.
That should have been your submission on the first instance, isn't it?
Yes, Your Lordship.
After discovering all these lacunas here
But
and there,
however, since there was some clarification with regards to the June to August, I was not aware of this letter date, 29/8/2022, Lordship.
yes, first thing is that June, July, August, what happened? Simply, you cannot say that I was busy in court cases. This is also a court case. He has been given a copy of the the judgment of the court and asking him to do what to do. You cannot say that I'll leave this case aside and I will be busy in other court cases. So there has to be some explanation. And surprisingly, he has not even explained this in his letter also, why the delay was there. Probably this 29/8/2022 is a reminder to him. You still have not furnished us the annexures. Where are the annexures? Probably that's the letter. Okay, next.
Next, it's Lordship, Annexure 9, page number 36, September 16, letter
Yes.
dated 16 September 2022.
Yes.
This was again forwarded by the forwarded to the Undersecretary, the otherwise comments, and they have sought additional time for taking necessary actions.
What additional time for necessary action?
Whether to file an appeal or there was an execution case
Oh, he has no
pending also in
business.
the
He has
High
no
Court.
business in filing an appeal. He has already recommended to the government, please file an appeal.
Yes.
So why does he seek for additional time? Is it something which is happening which I'm thinking? Execution case coming up?
Yes, it might be.
See.
Lordship, I have
Now, once he has prepared the
put it
Parawise
out in my
comments,
application that. Yes.
no, please listen. Once the DFO has prepared his notes and comments and recommended that an appeal should be preferred, which was in turn forwarded by the PCCF to the government, and he has also supplied the annexures subsequently. And now, why does he have to seek for time? To do what? Appeal is to be preferred through the government councils. The government will write to the government advocate. Government advocate will prepare. So it's surprising why he's taking time, unless there's something else. Okay, then 20th September.
And then on 20th September 2022,
What is this?
this is a letter stating their observation and intention to file an appeal, Lordship. 20th September 2022 to the Undersecretary. This was written by the DC Deputy Conservator of Forests, Mizoram Aizol.
Please read the letter. In continuation.
In continuation to the office letter number cited above, it is to state that the judgment and order dated 31/3/2022 passed by the Honorable District Court in Civil Suit 95 of 2011 has been carefully examined in this office. It is observed that the Honorable Court, while establishing the fact that the land and the teak plantation in question are located inside reserve forest and the LSC belonging to the plaintiff are issued inside reserve forest in contravention of the relevant laws, decided the case in favor of the plaintiff with a plea that the defendants did not file the case in the court for cancellation of the LSCs issued inside reserve forest The department is, however, of the view that any land parcels including LSC illegally issued inside notified reserve forest, should be treated as void and invalid by the Honorable Court. Hence, it is found befitting to contest the decision of the Honorable District Court through an appeal in the Honorable High Court. This was the observation made by the detailed observation comments of the department on the decision of this clause is enclosed here for further necessary action.
Then,
This was an observation made by the Deputy Conservator of Forest. And on 12 October 2022, this was the Undersecretary Forest Department has requested the Additional Government Advocate, District Court, Aizawl, to file an appeal.
District Court.
Yes, in the Guwahati High Court.
There are no government advocates in the High Court.
Yes,
Why did he
Lordship,
write to
that-
the District Court government advocate?
Lordship, that's why it has been resubmitted again to the Additional Advocate General on 26 October 2022.
And mind you, he's the Under Secretary.
And I have not been supplied a copy of this letter between the Additional Government Advocate and the Under Secretary. I don't know whether there's a letter. I'm not aware of it. So they have resubmitted again to file an appeal to the Additional Advocate General. That is on page number 40, Annexure 11.
Yes.
And Lordship, this has been received by the office on 28/10/2022. It is stamped in the bottom page, Lordship.
Yes.
And Lordship, on 7 November 2022, that is on page 42, Annexure 12, this letter was again sent to the Additional Advocate General to file an appeal. And also necessary documents for filing an appeal was again furnished to the Additional Advocate General. And in reply to this Lordship letter, letter dated 9 November 2022, page number 43, Annexure 13, the Additional Advocate General has sent back a letter to the Secretary Forest Department saying that the matter has been endorsed to the present Government Advocate. Lordship, I have stated in my application that this endorsement was not known by the present advocate, present Government Advocate. That is on page number 5 of my application, Roman number 8. The matter was endorsed to the concerned Government Advocate on 9/11/2022, and the endorsement was not known by the concerned Government Advocate. And on March, Lordship, when the status of the appeal was asked by the department, Lordship, the Government Advocate has sent back a letter asking for to furnish the documents.
Page 44 is a
Yes.
letter addressed to you asking you the up-to-date
Yes.
status. Page
Yes,
45 is
since
also
it was
another,
the letter was sent. Yes,
45 is also another letter addressed to you.
yes. There were two letters, Lordship. 44 and 45,
Then?
dated 7 March and 17 March. And as I've highlighted, as I have reflected in my application, Lordship, that the matter which was endorsed to me was not known by the present government advocate. On page 46, I've sent back a letter that is dated 21st March 2023,
Where is it written in
and
your,
I've asked them
just a
for,
minute, just a minute. Where is it written in your 21st March letter that you did not know about the endorsement?
Lordship, that I have not highlighted it,
Then
but I have written in my application, Lordship.
you may write anything you like in your application, but it has to has some basis. If it indeed was not known to you about the endorsement, you should have reflected to the officer that I've been endorsed, but I do not know that I was endorsed with this. So what did you write?
I've written it back saying that original certified true copies and the reasons of delay in filing the appeal and ad valorem court fees of rupees 11,000 are required to be required for preferring an appeal in the High Court. So they have sent it back on 16 May 2023. The original certified copy and the reasons for delay in filing an appeal. 16 May, and again on June, 2nd June 2023, they have furnished the court fees. And Lordship, as I've written in my application, they have furnished a wrong format of the certified true copy, so they have refurnished it again to the present government advocate on 4th July 2023.
So when did you file the appeal ultimately?
I filed the appeal on February 15, 2024.
So since 9th
It
November
was
20,
due to some technical difficulties, Lordship. Even I have mentioned this in other appeal also, Lordship. There are some technical problem with the government advocate computer. It was crashed and could not be retrieved. There are some other appeal also. I have mentioned this in my other appeal also regarding
where's that?
this. So it is in page number 7, point number Roman number 12 in the month of October.
October of which year?
October of 2023. And although it was finalized in the month of December 2023, there was some personal difficulty with the concerned government advocate.
So since 9th November 2022 up to the date of filing 15/2/2024, there has been
Yes.
series of communication up and down.
And Lordship, it was due to bona fide reasons mentioned in the application, Lordship. Moreover, there was some mistake on the part of the council also, Lordship.
What is the case regarding?
The case is regarding Lordship, the suit was filed in the trial court for registration of teak trees and permit for felling the teak trees, Lordship. The judgment and order is on page 11, page number 12. And the relevant portion is, Lordship, on page 28, the order.
The plaintiff has filed a suit for registration of the teak trees and for issuance of felling permits.
Yes.
That is the case. And what was your case?
Within their land.
Within their own land. So what was your
Yes.
case?
Our case is that, Lordship, the state has contended that the LSC is within the reserve area. So, moreover, the teak trees which they claim have planted by the plaintiff is under the departmental plantation by the
That
forest department.
that is the stand taken by you before the trial
Before the
court
trial court.
or in the appeal.
Before the trial court, Lordship. That was the stand taken by the government. And in the appeal also, Lordship, we have taken the stand.
Naturally,
The
you cannot keep on changing your stand. So the total days comes to 596 days.
596 days. And Lordship, I have some authority which I like to
Yes, like what?
submit, Lordship. 2022-23 10 SCC 531.
2000?
23 volume 10 SCC 531 para 35.
Name of parties?
Name of parties is Shivraj Singh through legal representative and others versus Union of India and another.
Yes. What does it say?
It says that if the Lordship permits, I'll read it out. We find that para number 35, Lordship.
Read.
We find that the High Court in the present case assigned the following reasons in support of its order. The law of limitation was founded on public policy, and that some lapse on the part of the litigant by itself would not be sufficient to deny condonation of delay, as the same could cause miscarriage of justice. 35.2. The expression sufficient cause is elastic enough for courts to do substantial justice. Further, when substantial justice and technical considerations are pitted against one another, the former would prevail. It is upon the court to consider the sufficiency of cause shown for delay, and the length of delay is not always decisive, while exercising discretion in such matters if the delay is properly explained. Further, the merits of the claim were also to be considered when deciding such application for condonation of delay. Further, a distinction should be drawn between inordinate delay, unexplained delay, and an explained delay, where in the present case, the first respondent has sufficiently explained the delay on account of negligence on the part of the government functionaries and the government counsel on record before the reference court. And Lordship, para number 40 and 41.
Yes.
We can profitably refer to quoting Lamkam, cited by Mr. Sen, where the same bench of the three honorable judges of this court which decided University of Delhi was of the view that the impersonal nature of the state's functioning should be given due regards, while ensuring that individual defaults are not nitpicked at the cost of collective interest. The relevant paragraph reads as follows. But while concluding as above, it was necessary for the courts to be conscious of the bureaucratic delay and the slow pace in reaching a government decision and the routine way of deciding whether the state should prefer an appeal against a judgment adverse to it. Even while observing that the law of limitation would harshly affect a party, the court felt that the delay in the appeal filed by the state should not be condoned. Regard should be had in similar such circumstances to impersonal nature of the government functioning, where individual officers may fail to act responsibly. This in turn would result in injustice to the institutional interests of the state. If the appeal filed by the state are lost for individual default, those who are at fault will not usually be individually affected. Para 41. Having bestowed serious consideration to the rival contentions, we feel that the High Court decisions to condone delay on account of the first respondent's inability to present the appeal within time, for the reasons assigned therein, does not suffer from any error warranting interference. As the aforementioned judgment have shown, such an exercise of discretion does at times call for liberal and justice-oriented approach by the court, where certain leeway could be provided to the state. The hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation so as not to allow the higher court to pronounce upon the legality and validity of an order of the lower court and thereby secure unholy gains can hardly be ignored. Impediments in the working of the grand scheme of governmental functions have to be removed by taking a pragmatic view on balancing of the competing interests. And Lordship, I'd like to submit one more citation. That is 2005, Volume 3, SCC 752, para number 8.
Lipokau.
Yeah, Lipoka. I believe Lordship
How many days delay
is aware of this.
in Lipokau?
Lipokau.
How much was the delay?
Lordship.
57 days
57 days, yes.
compared to your 596 days.
Lordship, however, there are some principles laid down by the Supreme Court.
Okay. Para 8.
This is regarding sufficient cause. Para number 8, para number 10, and para number 15.
Paragraph number
8.
8. And
Yes. Para number 10,
8, 10, 15.
10 and 15. Yes. And Lordship, one more, 2014, Volume 1, SCC 592.
2014,
2014, Volume 1, SCC 592.
592.
Yes.
Paragraph.
Paragraph number 8. This was all regarding the sufficient cause and that substantial justice should be advanced instead of the technical grounds. 2019, Volume 10, 2000 SCC.
Oh, one more.
408.
Huh?
Yes, one more, Lordship. 2009. This was actually I've already read it in 2023, Volume 10. They have highlighted it, Koting Lamkan. 2019, Volume 10, SCC 408. State of Manipur and others versus Koting Lamkan.
Paragraph.
Paragraph number 10. Paragraph number 10 and 11. Lordship, what I would like to pray to this honorable court is that let the delay be condoned so that the state appellants can have a can prefer. And Lordship, what I'd like to submit that is that, as I've already mentioned it before, that although there was some delay made by the government, made by the state, however, there was some also mistake made by the present government advocate also, but it was due to the reasons which was beyond control, and moreover, there are certain formal procedures which need to be followed by the government also. So the delay was made with the bona fide reasons, Lordship. So I've prayed this honorable court to delay, to condone the delay of 596 days, Lordship.
Yes. Mr. Malhotra.
If I may take your lordship to page 34, I'll just point out the negligence and the casual attitude of the applicants in filing the appeal, Your Worship. At page 34, annexure 7.
Yes.
If your lordship will allow me to read this letter dated 7th of June 2022, and it is written by the Deputy Conservator of Forest Headquarters to the DFO, Divisional Forest Officer, Darlon Forest Division, subject pairwise comment on judgment and order dated 31st March 2022 in Civil Suit 95 of 2011. With reference to the subject and letter number cited above, I am to inform you that the annexures required are not attached in the pairwise comment submitted via your letter, number and date under reference. Therefore, you are requested to furnish annexures supporting documents of pairwise comments for filing appeal in the Honorable Guwahati High Court, Aizawl Bench. And this is dated 7th of June 2022. Subsequently, Your Lordship, the DFO has written back to the PCCF, and it is letter dated 9th of September 2022. With reference to subject and letter number cited above, the undersigned is to resubmit herewith pairwise comments on judgment and order dated 31/3/2022 in Civil Suit 95 of 2011 with documents to justify the comments. And the reference is given is letter dated 29th August 2022. This letter dated 29th August 2022 has not been annexed to the application, Your Worship. But what I'd like to point out is that the annexures supporting documents to the pairwise comments was requested by the DCF headquarters on 7th June 2022. and it was furnished by the DFO only on 9th September 2022. That is after 3 months. After 3 months. And the reason for the delay is given at page 4, para 1, subclause 4, Your Worship. If I admit Your Worship to page 4, subclause Roman 4. During the month of June 2022 to August 2022, the DFO Dalon Force Division was attending to other urgent court matters pertaining to his division, and hence there was an unavoidable delay in refurnishing Paravai's comments. This is the explanation, but if we read the letter dated 9th of September 2022, this explanation has not been furnished in this letter. Nothing is mentioned in this letter dated 9th of September 2022 that he could not furnish the annexures documents earlier because he was engaged in attending other urgent court matters. So it is very clear that this has been concocted by the applicants to fill in the gaps. Thereafter, if your Lordship will kindly go to page 43. Initially, the state respondents at page 40, if I may take you to page 40 first. At page 40, the state respondents wrote to the Additional Advocate General requesting him to file the appeal. And again, page 42, they again wrote another letter to him requesting him to file an appeal.
Where's that?
Page 42.
These are additional documents.
Yes.
First of all, they say they file an appeal.
Yes.
Some additional documents were provided.
Yes. At page 43, Your Worship. Page 43 is the letter dated 9th of November 2022, written by the Additional Advocate General to the Forest Department, informing them that the matter had been endorsed to Ms. H. Lalmal Swami, Government Advocate, for preferring the appeal. So he informs them on 9th of November 2022 that the matter is endorsed to the Government Advocate for filing the appeal. And then if we go to page 44, the Forest Department writes to the Government Advocate on 7th of March 2023, requesting the Government Advocate to furnish the status report. So from November 2022 to March 2023, the department was just sitting back. They did not even pursue the matter. So from November 2022 to March 2023, the department did not pursue the matter at all with the Government Advocate, whether she had filed the appeal. November 2022 to March 2023, the department was just sitting back without pursuing the matter. Then, if your Lordship will kindly go to page 46. Page 46, the Government Advocate informs the Forest Department that to file the appeal, she requires certified true copies and the reasons for the delay, and the court fees of 11,000 rupees is also required. And in this letter, she does not mention anywhere that she was not aware that the matter had been endorsed to her. But in the application, one of the reasons for the delay is that the Government Advocate was not aware that the matter had been endorsed to her. But in this letter written by the Government Advocate to the Forest Department, nowhere is it mentioned that she was not aware that the matter had been endorsed to her by the additional advocate in November 2022 to file the appeal. Apart from that, in this letter dated 21st March 2023, the government advocate has requested the Forest Department to furnish her with the certified true copies, reasons for delay, as well as the court fees required for filing the appeal. And in reply, the Forest Department has furnished the required details as well as the court fees in piecemeal. If your Lordship will see, page 47, letter dated 16 May 2023, they have furnished her with the original true copies and for the reason for the delay in filing the appeal. At page 48, they have furnished her with the ad valorem court fees of 11,000 on 2nd of June 2023. Then again at page 49, they have furnished her with the original certified copies of the judgment and order dated 31st March 2022 on 4th of July. And at page 50, they have again sent her the legible supporting documents and English translation of documents on 17th of August 2023. So what I'm trying to point out here, Your Lordship, is that page 46, annexure 15, the government advocate requests the department concerned to furnish her all the required documents, court fees, original certified copy on 21st of March 2023. And the department took its own sweet time for furnishing the required documents as well as the court fees, and it could furnish the required details only by 17th of August 2023. So, after a delay of 5 months, the department was able to furnish all the necessary documents to the government advocate. 5 months it took them to furnish the required details. So, this clearly shows the casual attitude of the concerned department in pursuing the matter. It took them 5 months, Your Lordship. It starts from page 46. The government advocate wrote to the department on 21st March 2023 to furnish her the certified true copies, the reasons for the delay, as well as the court fees. And the department could finally furnish all the details only by 17th of August 2023. It took them around 5 months to furnish all the required necessary details. This clearly shows the casual attitude of the department in pursuing the matter. Thereafter, if I may take a lordship to the pleadings. At page 7. At page 7.
Yes,
Roman 11, page 7 of the application. So after receiving all the required documents, the explanation given for the further delay by the government advocate, by the applicants. It is given page 7.
7.
So the required documents were furnished to the government advocate latest by 17th of August 2023. Thereafter, if I read from page 7, para Roman 11, as you know, Chief Gone. On receiving the aforesaid materials, the counsel for the applicant started drafting the appeal, researching and studying of the case, drafting and compilation of documents have taken time in which some more delay had occasioned. In the month of October, unfortunately, due to some technical problem, the appeal which was already drafted and prepared was lost. And since it could not be retrieved due to crash of the computer, government advocate had to redraft the whole appeal from the beginning. Para 12. Appeal was finalized in the month of December. However, it could not be filed due to some personal difficulty from the concerned government advocate, and the appeal came to be filed on 15th of February 2024. So it's very difficult to believe that there's only one computer working in the office of the Advocate General of Mizoram. And it appears that the appeal was already finalized in December 2023, but it could be filed only on 15th of February 2024. There's another delay of more than 2 months. That is also very difficult to understand. What was the personal difficulty? Nothing has been explained, apart from making a bold statement that there was some personal difficulty faced by the concerned government advocate. So the application itself shows that there has been negligence on the part of the applicants in pursuing the matter. And the reasons for the delay given in this application are basically concocted just to try and cover up the gaps. Even the department itself took about 5 months to furnish the details to the concerned government advocate after she had requested them to supply the same. Then again, after it was furnished to her in August 2023, the appeal could be filed only on 15th of February 2024. Again, meaning from August, September, October, November, December, January, 6 months, it was lying with the government advocate to file the appeal. So it just shows that the applicants have not pursued the matter diligently, and it was due to the negligence on their part and the casual attitude of the department concerned that led to the delay. In this regard, Your Worship, I'd like to rely on the judgment of the Apex Court, 2020, Volume 10, SCC 654.
Para?
Para 4 onwards. I'll read from para 3, Your Worship, because para 3 refers to I'll read from para 3, page 656. No doubt some leeway is given for the government inefficiencies, but the sad part is that the authorities keep on relying on judicial pronouncements for a period of time when technology had not advanced, and a greater leeway was given to the government. LAO versus Katiji. This position is more than elucidated by the judgment of this court in Postmaster General versus Living Media (India Limited), wherein the court observed as under. It is not in dispute that the persons concerned were well aware or conversant with the issues involved, including the prescribed period of limitation for taking up the matters by way of filing a special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically merely because the government or a wing of the government is a party before us. Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. In our view, it is the right time to inform all the government bodies, the agencies, and instrumentalities that unless they have reasonable and acceptable explanation for the delay, and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months/years due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be swerved for the benefit of a few. Considering the fact that there was no proper explanation offered by the department for the delay except mentioning of various dates, according to us, the department has miserably failed to give any acceptable and cogent reasons sufficient to condone such a huge delay. Even in our case, Your Worship, they have just mentioned various dates, correspondence between them. They have annexed a lot of letters, correspondence between the parties. trying to explain the delay, but that cannot be taken as sufficient cause for condoning the delay. Para 4. A reading of the aforesaid application shows that the reason for such an inordinate delay is stated to be only due to unavailability of documents and process of arranging the documents. In para number 4, a reference has been made to bureaucratic process works. It is inadvertent that delay occurs. A preposterous proposition is sought to be propounded that if there is some merit in the case, the period of delay is to be given a go by. If a case is good on merits, it will succeed in any case. It is really a bar of limitation which can even shut out good cases. This does not, of course, take away the jurisdiction of the court in an appropriate case to condone the delay. We are also of the view that the aforesaid approach is being adopted in what we have categorized earlier as certificate cases. The object appears to be obtain a certificate of dismissal from the Supreme Court to put a quietus to the issue and thus saying that nothing could be done because the highest court had dismissed the appeal. It is to complete this formality and save the skin of officers who may be at default that such a process is followed. We have on earlier occasions also strongly deprecated such a practice and process. There seems to be no improvement. The purpose of coming to this court is not to obtain such certificate, and if the government suffers losses, it is time when the officer concerned, responsible for the same, bears the consequences. The irony is that in none of the cases any action is taken against the officers who sit on the files and do nothing. It is presumed that this court will condone delay, and even in making submissions, straight away the counsel appears to address on merits without referring even to the aspect of limitation as happened in this case, till we pointed out to the counsel that he must first address us on the question of limitation. We are thus constrained to send a signal, and we propose to do in all matters today where there are such inordinate delays that the government or state authorities before us must pay for wastage of judicial time which has its own value. Such costs can be recovered from the officers responsible. Looking to the period of delay and the casual manner in which application has been worded, we consider it appropriate to impose costs on the petitioner, state of 25,000 rupees, to be deposited with the Mediation and Conciliation Project Committee. The amount be deposited in for para 9. The special leave petition is dismissed as time barred. So, Your Worship, the Supreme Court in this case has also held that the law of limitation is applicable to everybody. It also binds the government, and the casual attitude of the government cannot be entertained. So even in our case, the application itself reveals the casual attitude of the department concerned in filing the appeal. No proper explanation has been given in filing the appeal. And if your Lordship will see, even the certified copy, which is annexed as Annexure 1 at page 11, the judgment was passed on 31st of March 2022. And if your Lordship will see page 11, the certified copy was applied for only on 14th of October 2022. Eight months down the line. 8 months before they even applied for certified copy. It just shows the casual attitude of the department in pursuing the matter. So my humble submission, Your Worship, is that since they have failed to explain the reason for delay, and the reasons given cannot be treated as sufficient cause for filing the appeal.
Is that all, Mr. Malhotra?
Yes, Your Honor.
Please write. Heard Miss H. Dalmal Swami, learned government advocate, appearing for the applicant, and Mr. A.R. Malhotra, learned counsel, appearing for the respondents. Stop by filing this application, comma, the applicants seek condonation of 596 days in filing the connected appeal against the judgment and order dated 31/3/2022 passed by the Court of Senior Civil Judge 1, Aizawl, in civil suit number 95 of 2011. By which the civil suit was allowed in favor of the respondents in the instant application. Next para, before we proceed to examine the application, it may be noted that as per office note dated 19/2/2024, comma, the number of days delay in filing the connected appeal has been recalculated by the registry and the same has been found to be correct as reflected by the applicants in their application. Stop. Referring to the application, the learned government advocate submits that a copy of the judgment and order of the learned trial court was forwarded to the applicant number 2 by the additional government advocate, District Court Aizawl, on 6/4/2022, and the same was received by the addressee on 7/4/2022. Stop. Thereafter, the Deputy Conservator of Forest, bracket headquarters, comma, Office of the Principal Chief Conservator of Forests, bracket PCCF, wrote to the Divisional Forest Officer, bracket DFO, close bracket, Darlon, Forest Division, on 20/4/2022, asking the state authority to submit parawise comments on the judgment and order of the learned trial court. Stop. Accordingly, the same was furnished to the PCCF on 5/5/2022. Stop. The Deputy Conservator of Forest, bracket headquarters, in the office of the PCCF, Thereafter, White, his letter dated 18/5/2022, wrote to the Undersecretary to the Government of Mizoram, Environment and Forest, Environment, Forest and Climate Change Department. Requesting that an appeal be filed against the judgment of the learned trial court. Stop. However, as annexures to the Parawes comments had not been annexed, in the communication dated 18/5/2022 of the Deputy Conservator of Forest Headquarters, the PCCF was asked to submit the same. By the Under Secretary of the same department for vetting by the Law and Judicial Department through letter dated 26/5/2022. Stop. The Office of the PCCF in turn requested the DFO Darlon Forest Division for the required annexures via letter dated 7/6/2022. Stop. However, since the DFO was busy not busy, cancel that, busy, was attending to other urgent court matters pertaining to his division, he could not immediately send the annexures and he could only send the same through his letter dated 16/9/2022. So, upon receipt of the annexures, what was the last sentence?
Rajab, I think it should be 9/9/2022.
Not 16/9.
9/9.
Instead of 16/9, you cancel that, you write 9/9/2022. of the office of the PCCF thereafter by letters dated 16/9/2022 and 20/9/2022 wrote to the Under Secretary to the Government of Mizoram, Environment, Forest and Climate Change Department, requesting additional time for taking necessary action as per the direction of the District Court, and also furnishing detailed observation and comments of the department on the decision of the trial court. Stop thereafter. The Under Secretary to the Government of Mizoram, Environment, Forests and Climate Change Department wrote to the Additional Government Advocate, District Court Aizawl, requesting the Government Advocate to file an appeal in the High Court. Similarly, the said authority wrote to the PCCF on 12/10/2022 requesting that all necessary documents be submitted to the Additional Government Advocate, District Court Aizawl, for filing the appeal. Stop. However, realizing that the request for filing an appeal should be made to the Government Advocate, to the Additional Advocate General / Government Advocate of the High Court, the Under Secretary, via his letter dated 26/10/2022, wrote to the Additional Advocate General to file an appeal in the High Court. Stop. In response to the same, I said 26/10, isn't it? Add one more, 26/10/2022 and 7/11/2022. Wrote to the Additional Advocate General for filing an appeal before the High Court. Then the Additional Advocate General thereafter informed the respondent number 2 that the matter has been endorsed to the Government Advocate concerned and all further correspondences be made to the State Council. Stop the Deputy Conservator of Forests Headquarters on 7/3/2023 inquired from the Government Advocate no, add one more date. On 7/3/2023 as well as on 17/3/2023 inquired the up-to-date status from the Government Advocate who was entrusted in drafting and filing of the appeal. And in response, the Government Advocate, through her letter dated 21/3/2023, requested the Deputy Secretary to the Government of Mizoram Environment, Forest, Climate Change Department to furnish original certified true copies of the judgment and order, the reasons for the delay and the ad valorem court fees of rupees 11,000 to enable her to prefer an appeal before the High Court. Stop the requirements were furnished to the Government Advocate on 16/5/2023, 2/6/2023, 4/7/2023, and 17/8/2023. Whereafter, the Government Advocate could start drafting the appeal. However, the appeal which was being drafted was lost since the computer crashed in the month of October 2023. So thereafter, the Government Advocate had to redraft the whole appeal from the beginning. The appeal was then finalized in the month of December 2023. But due to some difficulty of the Government Advocate, the appeal could be finally filed only on 15/2/2024. The learned Government Advocate submits that the factors which contributed in the delay for filing the appeal was due to various communications within the department and also in collecting the required documents and the court fees to prepare and to draft and file the appeal. Stop. She also submits that there was also some difficulty on the part, personal difficulty on the part of the government advocate to file the appeal to finalize the appeal. Firstly, due to the crash of the computer, which required redrafting from the beginning, and also some difficulties faced between December and the date of filing the appeal by the government advocate concerned. Stop. She therefore submits that the delay which has occasioned in filing the appeal is only for reasons beyond the control of the applicants and also for bona fide reasons, and therefore the delay of 596 days in filing the connected appeal be condoned. Stop. In support of her submission, the learned government advocate relies upon the following authorities. I'll just give you the citation only. Number 1, 2023, 10 SCC 531. Number 2, 2005, 3 SCC 752. Number 3, 2014, 1 SCC 592. And 2019, 10 SCC 408. Next para, Mr. A.R. Malhotra, the learned counsel for the respondents, on the other hand, by referring to the various letters enclosed in the application, submits that it can be seen that although the judgment was pronounced by the learned trial court on 31/3/2022, but a certified copy of the same was applied by the applicants only on 14/10/2022. Stop. He submits that when the annexures to the Parawai's comments was requisitioned from the DFO Darlon on 7/6/2022, the same could only be furnished on 9/9/2022. Stop. He submits that while furnishing the said documents, the said authority has nowhere mentioned that he could not furnish the same earlier on account of his engagement in some other important court cases relating to the division. Stop. Therefore, he submits that the submission made against paragraph number paragraph number 1, bracket small Roman 4, is only an afterthought. Stop. The learned counsel further submits that when the department had written to the additional advocate general / government advocate of the High Court to file an appeal on 26/10/2022 and on 7/11/2022. They did not pursue the matter, which can be seen from the letter dated 7/3/2023. To stop, he submits that it was only on 7/3/2023 that the department had made some query regarding the status of the filing of the appeal. Stop. He submits that when all the requisite materials to draft and file the appeal had been requisitioned by the government advocate on 21/3/2023 from the respondent authorities, from the applicants, all the requisite materials could be furnished in various stages by 17/8/2023. Stop. He submits that this only goes to show that the applicants have failed to pursue their case with diligence and consequently leading to the delay in filing the appeal by 596 days. Stop. He submits that since the time taken to file the appeal after a delay of 596 days, has not only been explained with sufficient reasons and explanations, but reflects the negligence and negligence of the applicants, the delay that has occasioned can only be termed as inordinate delay. Stop. Under the circumstance, the learned counsel submits that no ground for condoning the delay has been made out by the applicants and the application should be dismissed. In support of his submission, Mr. A.R. Malhotra, learned counsel, relies upon the case of State of Madhya Pradesh versus Behrulal, 2020, 10 SEC 654. We'll come back in 5 minutes. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Now, in the communication dated 18/5/2022, written by the Deputy Conservator of Forest Headquarters to the Under Secretary of the same department. I request for filing an appeal against the order of the trial court was made. But it is not known as to what materials had been furnished while requesting the filing of an appeal, since no, cancel that. What did I say? Please read. Okay, from that, but from but you cancel that and you rewrite. But however, it appears that the same was made without any annexures to the parawise comments, and for which the Under Secretary requested for the annexures via his letter dated 26/5/2022. Stop. Not stop, to the PCCF. Stop. The office of the PCCF in turn requested the DFO consent via letter dated 7/6/2022 for the annexures, which however was furnished only on 9/9/2022. No explanation has been made why the annexures could not be furnished. Immediately. Since it took almost 2 months, since it took over 2 months to furnish the said annexures. Stop. Stop. Ultimately, when the required materials were received, the additional government advocate of the district court ISO was informed through letter dated 12/10/2022 by the Undersecretary to the Government of Mizoram, Environment, Forest and Climate Change Department to file an appeal before the High Court. Stop. When the appeal is requested to be filed before the High Court, it is not understood as to how a request has been made to the additional government advocate of the district court. Stop. This goes to show that the department is not aware or rather oblivious about the functioning of government advocates in various courts. Stop. It may further be seen that despite writing to the Additional Advocate General on 26/10/2022 and 7/11/2022 for filing an appeal before the High Court, no further follow-up action was taken on the part of the department. And it was only on 7/3/2023 that a status report was sought from the government advocate concerned. Stop. The Additional Advocate General, through his letter dated 9/11/2022, had informed the applicant number 2, that the matter was entrusted to a particular government advocate. Stop. From the letter dated 7/3/2023 and 17/3/2023 of the Deputy Conservator of Forest Headquarters and the Deputy Secretary to the Government of Mizoram Environment, Forest and Climate Change Department, asking about the status of the appeal. Comma, it can be seen that they were aware of the fact that drafting and preparation of the appeal was entrusted to a particular government advocate. But despite that, as already stated, no follow-up action was taken after 7th of November 2022 up to 7/3/23 or 17/3/2023. To stop, it is further seen that the requisite documents and materials to draft and file the appeal was requisitioned by the government advocate entrusted with the case from the department on 21/3/2023. But the requisites have been furnished. Through different letters dated 16/5/2023, 2/6/2023, 4/7/2023, and 17/8/2023. Which goes to show that the department took their own time to furnish the requisite materials. Stop. What transpired after 17/8/2023? Has been explained by the applicants in paragraph 1, bracket small Roman 11, to TO2, bracket small Roman 14. Stop, the same is extracted here under. A to A, page 7 and 8. Next para, from the above abstract, it can be seen that what had happened after 17/8/2023 has been sought to be explained. But however, the explanation lacks substantiation by facts and figures. Stop. The learned government advocate has sought to, has relied upon the case of State of Nagaland versus Lipokau. Where it may be seen that in that case, the number of days delay was 57 days compared to the delay of 596 days in the instant case. To stop, it is a settled case that number of days delay in filing, number of days delay may not be relevant in all cases, but the cause and the explanation given for the delay is what is material. In the instant case, it is noticed that the explanations given cannot be said to be made with sufficient cause, since the facts and figures and the details or reasons for the delay. Have not been properly explained. Ah. Wherein it was held that the expression inverted comma open sufficient cause close inverted comma is elastic enough for courts to do substantial justice. And that when substantial justice and technical considerations are pitted against one another, comma, the former would prevail. The apex court in state of Madhya Pradesh and others versus Bherulal Supra had also taken into consideration the decision of the same court in the case of Postmaster General versus Leaving Media bracket India Limited 2012 3 SCC 563. wherein it was held that a liberal concession has to be adopted to advance substantial justice. But the department cannot take advantage of the various earlier decisions of the same court on account of the same court that the claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of modern technologies being used and available. Stop. The law of limitation undoubtedly binds everybody, including the government. Stop. The court therefore noticed that since the said decision 8 years have passed since then, and the decision of the apex court still remains unheeded. Stop. The court also observed that a preposterous proposition is sought to be propounded that if there is some merit in the case, the period of delay is to be given a go by. Stop. If a case is good on merits, it will succeed in any case. Stop. It is really a bar of limitation which can even shut out good cases. But this does not, however, take away the jurisdiction of the court in appropriate case to condone the delay. The court also observed that if the government suffers losses, it is time when the officers concerned responsible for the same bears the consequences. Mr. Malhotra, it was dismissed plus cost was imposed.
Cost was also imposed.
Dismissed and cost.
Berula.
Consequently, the Apex Court dismissed the special leave petition and at the same time imposed cost on the petitioner state stop. It is noticed that the department concerned has not been prompt enough in taking necessary steps to ensure that the appeal is filed within the time prescribed, and if not, as expeditiously as possible. Stop such exercise would be possible if the department is prompt to coordinate and meet the requisites by taking necessary steps through the officials concerned, including the government councils. Stop. As already noted, the department appears to be not in the knowledge as to which of the government councils are responsible to take care of cases in which in the particular courts concerned. Such lack of knowledge may be accepted if it comes from a layman, but not from a government official who otherwise is competent. Who otherwise is competent to cancel that from a government official. Full stop. While noticing the shortcomings as stated here above, it is further noticed that there has been laxity on the part of the assigned government advocate in dealing with the matter promptly, so as to ensure the filing of the appeal without prolonged delay. Which can be seen from the explanations as abstracted here and above. Next para. Upon considering the rival submissions and upon perusing the materials available on record and the authorities relied upon, this court is of the considered view that the applicants despite the notice shortcomings should not be deprived of a forum to ventilate their grievance. Stop accordingly. The delay in filing the connected appeal is condoned, which, however, is subject to the applicants depositing sum of rupees 15,000 before the registry of this court within 15 days from today. Stop. The amount so deposited shall be remitted to the High Court Legal Services Committee next para. With the above observation and direction, the application stands disposed of.
Obliged.
Yes. In the RFI, you write, in view of the order passed today in IAC number 30 of 2024, let the appeal be listed again after a week. Listed after a week. No, sorry, 15 days, I said, isn't it? Be listed again after 3 weeks on a date to be fixed by the registry. Office shall also put up a note. No, cancel that. In the meantime, the appellants shall file the acknowledgement of the cost imposed for condoning the delay. Before the registry. Yes.
For admission, item number 2.
I seek your lordship's indulgence in this matter, your lordship. If this can come up day after, on Thursday.
This is item 2, is it?
Item 2.
Who's for the other side?
I'm for MPSC.
Lordship, I'm appearing for the state respondent.
What is the matter?
It's regarding the promotion of the petitioners to the higher grade. Although the agenda papers was forwarded by the concerned department, AMC, through UDNPA to the MPSC, the MPSC have made a remark that since the agenda papers have not been forwarded as per the recruitment rules, they should re-forward it in accordance with the recruitment rules or amend the rules.
Post of
Assistant Town Planner. and
Assistant
Engineer,
architect and assistant
architect.
engineer. Yeah, 3 posts.
as paid for list the matter again on Thursday.
Item number 3.
Yes.
Lordship. Your Lordship, as per Order 16/8/2024, steps have been taken for service of notice upon the newly implemented respondent number 10. So, since my lord, the respondent number 9 has filed the compliance report with regards to the relevancy of the documents. My lord, I pray your lordship to make the appropriate order as per order 19 March 2015 that the respondent, who is the Central Defense Ministry, has to pay the rental charges amounting to a sum of.
No, see, what about this respondent number 10? Has he appeared? Have you taken steps?
Yes, my lord.
Is notice complete? Notice is served?
Yes, my lord. Everything is served.
Where is that?
Mary L. Kiangte, who is the respondent number 9.
Not 9, respondent number
10.
10. AD card is there? Miss Caroline, see, Deputy Commissioner, I don't know, is the respondent number 10.
Newly pleaded amendment.
I think you should inform the authority
Yes, my lord, I will inform.
about the pendency of this case. Because AD card has come back. It was signed on 27. What is the date? 27 what? 27/8.
My lord, if I may, I received affidavit filed by respondent number 9. I may be permitted to reply that affidavit, my lord.
Why? You're for which respondent?
Respondent number 9 is DC Nazuk Kumar.
And you appear for which respondent?
I am appearing for respondent number
248.
2, 4, and 8.
Why do you want to file a reply?
Because we are also at the meeting which was held on 6, which was held on 31st May 2023. We have some observation at that time.
So, didn't you file your own affidavit earlier?
We already filed it, however, as per this court order, some further meeting has been held on this day. And accordingly, the respondent number 9 filed affidavit. By submitting that meeting report, my lord.
You were there in that meeting.
Yes, my lord.
So whatever there's in the meeting will be reported, that's all. Where's the question of you replying to that affidavit of respondent number 9?
Because at that meeting, my lord, some observation has been raised by the respondent number 2, 4, and 8.
What observation was made is in the meeting resolution. They have, where is that meeting resolution?
Page number 6 of affidavit filed by respondent number 9.
You will do one thing, you will come back in the afternoon, right? Meanwhile, you just find out from the records, because this is quite bulky now. We don't know where's that affidavit also. Who's for respondent number 9? Any counsel?
Mary L. Kiente.
Where is she?
She's representing number 9 and 10, my lord.
Where is she?
She might not have been present today.
Just inform her. We'll come back at 2 and see what can be done. And you please inform respondent number 10 also. In the meantime.
Respondent number 10
Mary.
Ms. Linda, any information? Respondent number 10, anyone will be appearing or not?
I'm not aware of this case. It's item 3.
Item 3.
Miss Mary is taking up.
AD card has,
She's on screen.
yes, Ms. Mary.
Yes, sorry, my lord. My schedule out here is a little bit inconvenient, my lord. Sorry for that.
Okay, so what about this respondent number 10?
Respondent number 10, I have the instructions to appear on his behalf, but if I may be given a week time to file my power, my lord. Nevertheless, we have already filed whatever have to be submitted and whatever steps taken by the predecessor, my lord.
So will you be filing another affidavit or not?
My lord, even if I file, it will all be the same. It will be the replica of the respondent number 9. Because no fresh step is being taken at this stage. The matter can be posted for hearing, my lord. Because this matter has been pending since 2016 and it needs a detailed and meticulous reading, my lord, to go into the hearing.
Okay. When do we list it then?
After vacation, my lord.
See, one other issue is that, I don't know, I might have to recuse from this case.
Yes, my lord.
So I'll just pass the simple order then. List it before any other bench, not before the other side. You can record my name. Meanwhile, if you want to file your power and your affidavit, you file.
Yes, my lord.
All right.
Item numbers 4 to 6.
Yes.
Your Lordship, in this contempt, DC long line is transferred again. So you have to complete for formality. Only 3 months, they have changing.
So you want to file an application?
Yeah, just for the contempt. And the main case, WPC 90, item number
5.
yeah,
and 6.
5. In this case, Secretary to the Government of India, Ministry of Road, Transport and Highway, yet to file the affidavit.
My lord, for respondent number 8, Ministry of Road Transport and Highway, I already received instruction and I drafted my affidavit and sent to the department for vetting. I may be given 2 weeks' time for filing my affidavit.
In which writ petition? 15 or 19?
90.
Item number 6.
2019.
Okay. Ms. Dinariti Azul, learned counsel appearing for the petitioners. In contempt case C number 1 of 2020, submits that She may be given how much time?
Just 2 weeks time.
2 weeks time to file an application to implead the new incumbent holding the post of Deputy Commissioner Longklai, since the earlier incumbent has been replaced. Stop, Ms. Zaram Sangpui, Lanet CGC, appearing for the respondent.
In item number 7, my lord.
Not in contempt.
No, I am not a party in the contempt.
I
my
know,
lord.
respondent.
Number
which is
8.
Number 8 in WPC number 90 of 2019. Respondent number 8 in WPC 90 of 2019. Bracket, what is the department? Ministry of
Road Transport and Highways.
bracket Ministry of Road Transport and Highways, close bracket, submits that she has sent the drafted affidavit for vetting, and therefore she may be granted 2 weeks time to file the affidavit in opposition. Yes, anything else?
Lordship, I am appearing for respondent number 6 and 7 in item number 6.
WBC 90?
Yes, my lord.
Yes, what is your submission?
Yes, Lordship, in this particular case, we are basically pro forma respondents, and as per the instruction, we will not be filing affidavit on behalf of respondent number 6 and 7.
Okay, your good name?
Arlal Munsiama.
Mr. Arlal Munsiama, Learned Counsel for respondent numbers 6 and 7 in WPC number 90 of 2019, submits that the respondent numbers 6 and 7 are only pro forma respondents, and therefore they will not be filing counter affidavit. Stop. Next para, in view of above, let the matter be listed again after the ensuing puja vacation. Stop. Meantime, the parties are at liberty to exchange their pleadings. Yes.
Item number 7.
My lord, in this case,
One more, just a minute, one more line. Exchange their pleadings and also file application for impleadment in the contempt petition, if so advised.
my lord, in this case also, if we may seek one more time for filing the impleadment application.
Impleadment?
Yes, my lord, we were supposed to, we had
Implead who?
implead JICA, my lord, because this case is about the JICA guidelines, your lordship might remember.
Yes. How much time?
My lord, 2 weeks.
As paid for by Mr. Joseph Elrentley, Learned Counsel for the petitioners. Further 2 weeks time is granted for filing impleadment application. To implead whom?
My lord, JICA. 1 minute, my lord, it's there in the order already, my lord.
To implead the authorities in JICA, JICA, capital letters. Yes.
Yes, deeply obliged, my lord.
Item number 8.
Yes.
Lordship, actually, this is challenge to two actually orders of the electric department, lordship. This is MES service rules, lordship. And
Pleadings are complete?
pleadings complete, my lord. The petitioner's lordship, herein non-graduate engineers in the junior grade, lordship.
Just a minute.
This actually is more or less of a covert matter, Lordship.
Respondent numbers 4 and 5 are promoted or just posted?
Actually, they earlier were on non-functional, Lordship. But that their posting to that vacancy eats away a quota, Lordship. And on that line, my lord, this bench in another case, Lordship, had passed order in WPC 63 of 2020, Lordship.
No, question is, this private respondent numbers 4 and 5 are promoted to the functional post or they're just posted to the functional post? You are non-graduate, they are graduate.
They are graduate, Lordship.
And
the vacancy,
quota is 80-20.
80-20.
So the post was vacated by a non-graduate engineer.
My lord,
Instead of posting
the non-graduate,
non-graduate, they have posted the
the
graduate engineer.
engineers, Lordship.
So it's basically a case of posting.
Actually posting, but for me, my lord, earlier I was in the junior grade before my promotion. So the impugned order, Lordship, at page 41,
You were in the junior grade.
my lord. Coordinate bench of this court, Lordship. In the case of W. Lalthan Puya, my lord. And also there is
The private respondents 4 and 5 are also junior grade.
no, my lord. It seems
What are they?
they were already senior grade non-functional, my lord. Prior to the posting order, impugned hearing.
Okay, senior grade. So the post available was senior grade.
Senior grade, Lordship.
Senior grade functional.
Functional, my lord.
And
Earlier-
it was occupied by
Non-functional.
non-graduate engineers. Non-graduate engineers.
Prior to its vacancy, my lord.
Correct. Prior to its vacancy, it was occupied by non-graduate
Non-graduate
engineers.
engineers, Your Lordship.
When it became vacant, instead of promoting non-graduate engineers from the junior grade, such as the petitioners, how many petitioners?
2, my lord.
Such as the 2 petitioners, they have posted
My lord. The graduate engineers,
Graduate
respondent number 4
engineers.
and 5.
from non-functional to functional.
Non-functional to functional, Lord.
They were already non-functional, senior grade.
Yes, Your Lordship.
Okay. So in that view of the matter, the rules have been violated.
Violated,
That's
Your
what you're
Lordship.
saying.
My lord. Because now we are fighting for the functional post, Lord. Since
What do they say in the counter affidavit?
counter affidavit, nothing has been rebutted on that point, my lord. They simply rebutted on the point of post-based and vacancy-based roster, my lord. But that actually is not an issue in the present case, my lord.
Post base.
And vacancy-based. They dwell so much on that issue only, my lord. And regarding my contention that this quota system, my lord, they have not rebutted anywhere, my lord, in the affidavit filed by the state government.
Notice is complete on 4 and 5.
Complete, lordship.
They have not appeared.
Not appeared. Not
How did you
responded.
serve by Dusty?
Dusty, my lord. Prior to that, Dusty, my lord, it was AD card was also sent, my lord. Oh.
Show me the impugn order.
Page number 41, in lordship.
41.
41 and 42.
What was that vacancy?
The
Lungle. E.
before. Yes, Your Lordship. Now, the
Lungle Circle.
EE,
Lungle Power Circle.
serial number 2, Your Lordship. Serial
And
number 2,
and the
Engineer
other-
David Chakma.
The other vacancy was EE Commercial.
When we are concerned here on page 41 with serial number 2, Engineer David Chakma. And that is another one and on page 42, Your Lordship.
Serial number 4.
Serial number 4.
So the vacancy was EE Commercial and EE Lungle Power
EE,
Circle.
My Lord.
So these two private respondents are basically executive engineer, non-functional.
Earlier, they were SDO senior, my lord, prior to their posting in the impugn order, my lord. They were SDO senior, as was usual in case of non-functional promotee, lord. Before that, my lord, they were on non-functional promotion.
But see, the order says senior grade of MES,
That
non-functional.
is, yes, actually, their promotion to the senior grade was non-functional.
Grade is senior grade, non-functional. But the post they were holding was SDO senior.
My lord.
Is there a post like that, SDO senior?
SDO senior actually, my lord, is junior grade, my lord, in the posting. They do not hold any responsibility different from that of senior grade, my lord. The post that they were holding immediately before their promotion on non-functional, they keep on holding the same. And the only difference is their designation.
Designated as what?
As SDO senior on their promotion on non-functional, my lord.
Okay.
And financial upgradation is also there.
Without promotion, there'll be just SDO.
Just SDO, my lord.
On their promotion
On non-functional,
to
they will be
non-functional post,
designated
there'll
as SDO senior.
is that nomenclature available in the recruitment rules?
My lord,
Where is that?
it is there in the schedule to,
Schedule.
my lord, schedule to the MES rules. Page number 35, your lordship. 35 of the petition.
Senior SDO. Okay, now what is the other rule which you say that has been violated?
If I may take lordship to rule
2018.
22.5A, lordship. If I may read, lordship. To fill up vacancies in this grade, a member of the service in the junior grade who had completed not less than 5 years continuous regular service in the junior grade and have passed departmental examination in engineering accounts conducted by the commission shall be eligible for consideration from promotion by selection method.
You have
Provide-
passed. You have passed
We have
departmental
passed.
examination.
Passed, my lord.
You have completed 5 years also.
My lord. Now 9 years running, my lord.
Okay.
So there is one proviso, provided that 80% of the posts, my lord, shall be for direct quota and 20 for promotion quota. And now the cadre strength, my lord, cadre strength in the department is 34. The whole cadre strength of the senior grade, my lord, is 34.
Yes.
Plus non-functional. And the quantum of that non-functional promotion, that is not, my lord, provided. It's just NF, non-functional. And out of that 34, my lord, 27 will be for the graduates. And the remaining 7 posts, my lord, will have to be reserved for the diploma, my lord. Altogether, they are 34.
34.
And presently, my lord, by now issuing this impugn order, my lord, the graduates now hold 29, my lord. 29 or 30, I'm not, my lord, I'll check it. And we are now only 5, my lord. 5. That is now they have
From
been
where can we see that? 29 and 5.
my lord. That I made it in my pleadings also, my lord.
Page,
And all,
page. Readings where?
page 6, paragraph number 9, my lord. Page 6.
What is the reply?
In the state government, my lord.
Paragraph 4.
Also have not reported to that effect also, my lord. Since that is the status are on the date, my lord.
At present, there are 27 direct recruits and 5 promotees.
And in the affidavit filed by the state government, my lord.
See, yes, paragraph 4.
Para 4, yes.
What about the other 2 posts? They say that there are 27 direct recruit, graduate,
My lord.
and 5 promotees, non-graduate.
My lord.
This both, if you add them together, it comes to only how much?
Present there are
32.
32.
So what about the 2 other posts?
That I think, my lord, have not been filled up as on date of filing, my lord. Because even after filing the case, my lord, there are vacancies accumulating, my lord. But at that time when we filed in the order which we have challenged, my lord, that was issued on April, my lord. We were already qualified, my lord, to be promoted. And at that time, my lord, we were the eligible candidates from the diploma quota. And that quota which they have filled up by the impugned order, my lord, were meant for the diploma, my lord. And
See, this 27 and 7 and 27 and 5, they say. This 27 direct recruits, do they include the private respondents or without them?
that have, my lord, not been specified. They simply said, the current strength of so and so, out of this it is, at present, they say at present, my lord.
See, your allegation is that your averment is that there is 35.
My lord, no, 30, there is, my lord, one Zeda post, which is outside the Qadar post, my lord. That Zeda was also counted within this 30, my lord.
Within this 35.
35.
So is it to be counted or it's not to be counted?
Actually, that, my lord, is outside the Qadar post.
So then you should have said it's 34 then.
Has to be, yes, 34. Means,
Out of which graduate engineers should occupy 28 posts,
my lord,
including Zeda,
including Zeda, my lord.
and non-graduate engineers should occupy 7 posts.
Yes, of the senior grade.
However, as on date, the graduate engineers, their groups are currently occupying 30 posts.
30 posts. That is including Zeda, my lord. So,
And you are occupying 5 posts.
5 posts,
You are means the non-graduate.
my lord.
Now, paragraph 5, they say that, not paragraph 5, paragraph 4.
4.
4, they say 80-20 means 27 and 7. And they say 27 direct, at present there are 27 direct recruits. This includes the private respondents or not?
It seems it included private respondent, my lord. And one thing, my lord, at the time of filing their affidavit, there are already 2 additional vacancies, which were not there at the time we filed the petition, my lord. There are continuing vacancies. And even now also, my lord, there are also some more vacancies.
What
available.
vacancies is that?
Vacancies in the senior grade.
No, to be filled up by whom?
That, my lord, has to be decided as per the rules, my lord. And now we have challenged the order that was issued way back in 2000, April, my lord,
So
April
what,
4th.
so what does the rules say? What, how priority is to be given when there is vacancy? Who will fill what?
The rules said that 20 has to be for the diploma, 80 has to be for the graduate engineers. That means at the time when this filling up of posts was conducted, my lord, that rule was violated in April 2023, my lord.
So when did the vacancy happen? Any statement to that effect?
Yes, Your Lordship. Regarding that,
You just said that 2 more vacancies occurred. Is it in the affidavit or?
no, that, my lord, happens on only after filing of the petition.
So it must be in the affidavit. It cannot be in your writ petition because after filing writ petition, vacancy has occurred. So how do you say, from where did you say that there are 2 more vacancies? Is it paragraph 10 of the counter affidavit? Just see. This is in relation to the,
It's, yes, my lord, it seems to be this one. I say that matter has been put up wrong with. Yes, my lord. 2 vacant posts of senior grade and was discussed under chairmanship of Power Minister. And including that, my lord, now the post which becomes vacant now is 2, my lord. And at the time of filing the petition, there were no vacancy. Actually, they were filling up posts which is beyond their quota, my lord. The graduates were filling up posts beyond and above their quota,
oh, that is your allegation.
my lord.
Now, this paragraph 10 is in response to your statements in paragraph 19 of the writ petition. How do we understand this paragraph? Tell me.
Which one, Your Lordship?
Paragraph 19 of your writ petition says that they have failed to comply with the demands of the petitioner by promoting graduate engineers on 5th April and 20th April,
My lord.
which is the rightful place of the petitioners. What they have replied is they said, I say that the matter has been put up along with proposal for filling up 2 vacant posts of senior grade and was discussed with the chairmanship. What do you mean by that? This is the affidavit. Ms. Caroline, what do you say?
This affidavit was signed by Mr. Sagar, and I have been recently enrolled in this matter, and if I may be allowed to get clarification with regards to para 4 and para 10 of my affidavit in opposition.
If I may help, my lord.
What clarification you want?
Regards to what has been stated in the affidavit in opposition.
Gather strength is 34 plus non-functional as per the rules, correct? Let us come to that rules. Where is that page? The schedule.
Page 21 onwards.
No, 35.
35 is the schedule.
Senior grade 34 plus NF.
NF.
Now, NF remains NF. After promotion to the senior grade, they still remain as SDO, but senior SDO.
Senior as well.
And they are also non-functional.
Non-function. And regarding the,
Only thing they get is their pay.
yes, financial upgradation, that's all.
Financial upgradation is them.
There is no advancement at all regarding their responsibility also. They
So that is 34 plus NF. 34 are the posts.
are the
number
posts,
of posts
actually functional
available.
posts which they held.
Functional posts available are 34.
34 years.
80-20 means 27 by 7.
My lord, exactly.
Now, Zeta post, nobody mentioned. You had mentioned it, Zeta.
Yes,
but
my
they have not mentioned Zeta.
My lord.
Rules also do not mention Zeta. If you include Zeta, it's 35, you say. But since it's not mentioned in the rules or in the affidavit, we'll not refer to that. So, according to them, so far now they have 27 functional posts
As of
from
now.
amongst the graduate
My lord.
engineers, and
This-
which includes the private respondents, or which does not include the private respondents.
It includes the private respondent number 1, my lord. And number 2,
If
regarding,
it includes the private respondents, then their quota is still met.
no, my lord.
27.
27, my lord.
They cannot exceed 27, according to you.
That is,
So
my
if there are 27 today, including the private respondent, nothing is violated.
I agree with lordship. As of now, that is correct. But at the time when this impugn order was issued, I am now, if simply because if my representation is in respect of this present new vacancy, it can now be accommodated. But I, my lord, have to be promoted prior to the private respondent, my lord. Because at the time of their promotion, my lord, I was already there.
See, I understand. Now, first thing first. Where is that vacancy? Who says that there is vacancy now? Because the vacancy has not been mentioned anywhere specifically.
Vacancy, my lord, is
Paragraph 10, they have mentioned vacant post. But this, again, it relates to your paragraph 19. Paragraph 19, you never said there are vacancies of additional vacancies.
that, my lord, these additional vacancies is not within our knowledge at the time of filing, because that happens only after filing of the petition, my lord. These present 2 additional vacancies.
So, from where do you derive that additional vacancies?
That, my lord,
What is the source of information that there were 2 additional vacancies? From where are you saying that?
that, my lord, apologies that there is no, I have not filed any addition, any affidavit to that effect.
Okay, you have not filed, okay, fine, but from where did you know
But
that there are 2
That is
vacancies?
from my information which I received, my lord. However, as I submitted, my lord, is not put in record, my lord.
Then we don't know, then if it's not in record, we are not aware about any such vacancy. At any rate, it's not your case that since there are now new vacancy, you should be considered as per the, against that new vacancy. That is not your case. Your case is that you should be considered instead of these private respondents. Isn't
For
it?
that, my lord, yes, if I may take lordship to my seniority, my lord.
Seniority will be different.
But
How can you compare your seniority as non-graduate with the seniority of graduate engineers? Is there a common seniority?
there is that, my lord, no common.
Then-
There has to be a separate seniority because quota system is still, my lord, surviving till
No,
date.
it is one thing to say there has to be, and it is another thing to say there is a seniority. There is a separate seniority. Which one is the position?
If I may take lordship to page 36, lordship. This is seniority list of officers, lord, as on date of 1/5/23, my lord.
Comprising of which officers?
officers under PAD department,
Entire officers.
entire officers,
We are concerned
including
with only,
JSC.
we are concerned only with junior grade.
It's all included here in my lord.
Now, is there a common seniority between the graduate and non-graduate?
No, my lord, in terms of the earlier orders issued by disciplinary court in various other cases, my lord, the common seniority was done away with, and separate seniority was prepared, my lord. And that actually was in terms of the quota system, my lord. Because quota still survive as long as there are officers who are on the post of junior grade, my lord, as on date of the date when these 2013 rules came into force, my lord. And for that, my lord, if
You're not prepared, it seems.
may be allowed, my lord, to file additional affidavit incorporating the date, how these two vacancies came into effect, my lord, which is now pleaded by the government in their affidavit, my lord.
Which vacancies? Occupied by
Vacancies
whom?
stating that, my lord, they were actually initially at the time of the impugned order vacancies which is available for the petitioner, and thereafter, only after filing of the petition, these two new vacancies arises, my lord.
No,
Incorporating all these, my lord.
it is nobody's case, as from the records, that there are 2 more vacancies.
That exactly, my lord.
Nobody's case.
So
So why are you bringing up that concept of 2 more additional
that, my lord,
vacancies?
yes, because this
From where are you saying that? It is not in the record that there are 2 more vacancies. Even if there are 2 more vacancies, it is not your case that you should be considered against the 2 vacancies which has now happened. Your case is that you should have been considered for promotion when these 2 private respondent number 4 and 5 were promoted.
my lord.
Instead of them, it should have been you.
Yes, my lord. Exactly.
That is your case. It is not your case that now some more vacancy is there, so I should be considered against the vacancy.
No, my lord.
So,
No, actually,
so why should you file additional affidavit just to bring on record the vacancy available?
to bring
as
on
of
record,
today?
lordship, the query is raised by lordship, my lord, saying that now since the vacancy which is now already there, then the true vacancy remains. So what's the issue, my lord? That is your query is raised by lordship. So to answer to that, my lord, I think it will be proper if I file additional affidavit incorporating all those issues, my lord.
That is one thing. Another thing is, can it not be disposed of at this stage itself? Instead of you having to file another additional affidavit.
That, my lord, is my prayer actually, because there are now
Your endeavor should be that,
Promotion-
get it disposed. Why you want to file additional affidavit?
promotion, my lord, has been installed, my lord. There are, even after these 2 vacancies, to my information, my lord, there are also another vacancies coming up, my lord. And for all these
Maybe.
vacancies,
Maybe. If you are satisfied that in the vacancy which is happening today, you should be accommodated, we'll
no, my
accordingly
lord,
dispose it of.
not that, my lord. That is
Then-
not, my lord.
then why do you want
my
to-
prayer is only regarding, my lord, the vacancies which already have been filled up on 5th of April, my lord,
By the private respondents.
by the private respondent.
You stick to that. So there may be 10 more vacancies that may be filled up as per the law, as per the rules. Your concern is the vacancy which occurred in April should have been filled up by you.
The first one was 5th of April, my lord. And at that time, my lord, I was the one who is available from the diploma cadre, my lord, to fill up the vacancy. And for that, my lord, if I may take lordship to annexure number 1, page 14, 14, lord.
Yes, what is there?
This is regarding petition number 1.
Where's his name?
Lalmal Sawa, my lord.
Petition
If I
number
may read,
one.
lordship.
This is what? Appointment?
Appointment,
Initial appointment?
initial, actually, he was, yes, from this time onward, my lord.
This is a promotion.
He is now promoted to junior engineer, my lord. That is junior grade of MES. And from this date onward, my lord, his service in the MES has to be counted. And by counting his service from this time, my lord, that is 17 December 2014, my lord. And as on date of, my lord, the impugned order was issued, I was already in service in the MES service, my lord, for about 9 years.
Okay, come to page 15. Who is this?
Page 15 is petition number 2, my lord.
Serial number?
Serial number 2, B. Rao Thang Liana. And he was promoted to junior
December.
grade,
It's in April 2017.
17, my lord. And by the time, he was already in service for 6 years, my lord. That means, my lord, in terms of senior grade, Rule 22(5)(a), my lord.
He was already in service as junior engineer, but not as junior grade. Junior grade service will count only from 28th April 2017.
My lord,
And when was the vacancy? When did the vacancy happen? Occupied by this respondent number 4 and 5. Required number of years is 5 years, isn't it?
my lord, 5 years.
When
Plus, pass, they have to pass exam in engineering and accounting.
Have you passed
I passed, my lord.
both?
Both.
Both the petitioners?
Both of them, my lord. And for that, my lord,
And the 5 years has to be,
Counted-
5 years service, 5 years is to be counted from the
From
date
the-
of passing or not, or from the date of promotion?
no, my lord, from the day they joined the service, my lord, the junior grade.
Okay. So this vacancy, when did it happen? On which respondent numbers 4 and 5 have been transferred and posted?
Prior to this, my lord.
There still appears to be some confusion. You say that this is a covered case. Where is that judgment?
Yes, this is 2000, in the case of Lal Thanpuya, my lord.
Only one case.
One case, my lord, there are also another case which.
What does it say? This judgment. What does
In
it say?
this judgment, my lord, a similarly situated person in the same department, electric department, my lord, having exactly the same problem, my lord. Here also, the diploma engineers,
What is the decision? That's what I'm asking you.
the decision, my lord, is at paragraph number 11, your lordship. The notification appointing the private respondent, my lord, have been quashed, set aside, my lord.
Oh, you should have produced the other one.
Which was,
WPC 63.
my lord, this is 63, my lord.
Not 60, I'm sorry.
Which one?
6319. Yes, 6319. This is 6320.
My lord, this is also same, my lord. Same,
No, this WPC number
relies on
63
19.
2020 relies upon WPC
19.
number 63 of 2019. Where is that WPC 63 of 2019 order?
That I can supply, lordship.
You should have bought it today.
Since it's actually, or not on online, my lord. This is the one which is available online, my lord. So I have it. 19 is not there on the website. However, my lord, the facts of the case is quite clear, my lord, even from reading this.
Please get the records. 63 of 2019.
If I may read, Lordship, from paragraph number 7, Lordship.
Yes, read.
The present can involve engineers of electric department, cadre of MES. This court was seized of similar matter pertaining to page C, cadre wherein graduate engineers who had been promoted earlier than the private respondent in the non-functional senior grade of EE were subsequently promoted to functional grade of EE. In the quota reserved for non-graduate in terms of Rule 22.5b of the 2013 rules, on the ground that they were senior than the non-graduate engineers in the non-functional grade of MES. The court, vice so, passed in 6319, held that 22.5b of the amended 13 rules, which was amended in 17, could not have applied by overlooking 22.5a. Inasmuch as 22.5b would come into play only when vacancy occurs against quota meant for graduate engineers. In the present case, the petitioners are diploma holders, while respondent number 5, 6, and 7 are graduate engineers. Private respondents have, however, been promoted to the post of functional grade of senior grade only on the ground that they had been promoted earlier in time as non-functional EE than the petitioners. This court on proceeding order dated so passed in 6019 is in respectful agreement, my lord, with the decision made by the coordinate bench. Inasmuch as Rule 22.5b of amended 2013 rules would only be applicable with regard to promotion of similarly situated persons, the state respondent have made fundamental error in putting the case of the graduates and non-graduates in one basket, when the rules provides for quotas for promotion, regard being had as to whether they were diploma holders or graduates. In view of the above, this court is of the view that the judgment order dated so passed in 1619 covers the present case. The case is accordingly disposed in line with judgment order so passed in 1619. Assess promotion of so-and-so, which comes within the quota meant for diploma holders is not sustainable in law. Accordingly, the notification dated so-and-so issued by respondent number 2 is set aside, insofar as it pertains to respondent number 6 and 7. Consequently, the respondents are directed to consider the case of the petitions, along with other eligible candidates for promotion to vacant functional grade, senior grade posts of electric department.
Miss Caroline, anything to say?
If I may be given some time to clarify about the petition which my learned friend had produced, and I don't have the copy.
This court intends to dispose it of. Please write down. Heard Mr. C. Zoram Chana, learned counsel for the petitioners, and Miss Caroline Kelung Oipui, learned government advocate, appearing for the respondent numbers 1, 2, and 3. Stop. None appears for respondent numbers 4 and 5, despite notice. Stop. Next para. By filing this writ petition, the petitioners have questioned the order of transfer and posting of the respondent numbers 4 and 5, white notifications dated 5/4/2023 and 28/4/2023. to the senior grade of the Mizoram Engineering Service, bracket MES, close bracket, functional. Stop. According to the petitioners, the two posts in which the private respondent numbers 4 and 5 have been posted are meant for non-graduate engineers. And therefore, the said private respondents, being graduate engineers, could not have been transferred and posted. As shown in the impugn notifications. Stop. Mr. Caesar Ramchana, learned counsel for the petitioners, submits that as per the proviso to Rule 22, bracket 5, bracket small a, of the Mizoram Engineering Service, bracket amendment, close bracket, rules, 2017. Open bracket again, rules of 2017, close bracket, comma, 80% of the posts of senior grade is reserved for direct quota, bracket, graduate engineers, close bracket, and 20% for promotion quota, bracket, non-graduate, close bracket, full stop. He submits that as on the date of the issuance of the impugn notification, impugn notifications, comma, there were already 27 graduate engineers out of the 34 sanctioned posts of senior grade of the MES, comma, P and E cadre. And therefore, the private respondents could not have been posted. In the functional post, as reflected in the impugn notifications. Stop. He submits that out of the 7 posts meant for non-graduate engineers in the senior grade of the MES, there are only 5 non-graduate engineers holding the post of senior grade functional. Stop. Therefore, the impugn notifications dated 5/4/2023 and 28/4/2023 should be set aside. And the petitioners who are otherwise qualified cancel otherwise, who are qualified as per the rules of 2017 should be considered for promotion. What is the stand in the affidavit? Okay, I add one more line. Mr. C. Zoramchana, Learned Counsel, also submits that the instant case is squarely covered by the decision of this court in WPC number 63 of 2019 and WPC number 63 of 2020. Both are 63. Okay. One is 2019, one is 2020. Next para, Ms. Caroline K. Lungoipui, Learned Government Advocate, on the other hand, by referring to the affidavit of opposition filed by the official respondents on 7/3/2024, submits that. Which one? Paragraph 5?
Yes, my lord. Page 2.
Due to the implementation of office memorandum dated 9/8/2021, all departments are to maintain vacancy-based register for identification of quota where 2 or more methods of recruitment are provided in the relevant recruitment rules, service rules. Stop. That every vacant post in the senior grade of MES electrical close bracket have to be filled up in accordance with the above mentioned office memorandum. And that the office memorandum has done away the post-based roster by replacing it with vacancy-based roster. Where's the annex office memorandum? Page. Anything else apart from this?
constitute a vacant post by the parents and
Stop. She further submits that in respect of the two vacancies in the senior grade of the MES bracket electrical, the matter was discussed with the under the chairmanship of the former power minister on 10/11/2023, attended by the representatives of DPNAR bracket GSW and DPNAR bracket ARW. And it was decided that the promotion be processed as per the Mizoram Engineering Service rules and the standing instructions of the government. So, insofar as the reliance of earlier decision of this court is concerned, the learned government advocate submits that she may be given some more time to examine the same or to obtain instructions. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Full stop. The specific case of the petitioners is that the rules of 2017 clearly provides for reservation for graduate engineers and non-graduate engineers in the senior grade of the MES. Stop. 80% of the posts is reserved for direct quota, while 20% is reserved for promotion quota. Stop. The petitioners, being non-graduate engineers, belong to the not belong to, are covered by the quota meant for promotion. Stop. The state respondents in their you cancel that line, the state respondents. Full stop. Where's your averment about the Mr. Zoram Sinha?
My lord,
Regarding currently, how many posts are there?
from the state affidavit, my lord,
Your
my
petition.
my petition is
The-
9.
Okay, please write like this.
But 9.
The writ petitioners, at paragraph number 9 of the writ petition, have taken the stand that the current strength of senior grade of the MES bracket, what do you call it, electrical or MES
Electrical cadre, my lord.
PNE cadre? No. MES bracket PNE close bracket is 35,
PNE cadre.
out of which 28 posts are occupied by senior grade who are graduate engineers. And out of the 7 posts meant for non-graduate engineers, there are only 5 posts filled up by non-graduate engineers. In view of the impugned notifications posting the respondent numbers 4 and 5 as senior grade functional, full stop. The learned counsel for the petitioners has, however, clarified that one post is an ex-cadre post belonging to Zoram Electrical Development Corporation.
My lord.
No, not
Agency.
agency, not corporation. Zoram Electrical Development Agency, bracket ZEDA, which is also occupied by a graduate engineer. Most of the state respondents in their counter affidavit at paragraph number 4 have stated that at present there are 27 direct recruit bracket graduate close bracket engineers and 5 promotees bracket non-graduate close bracket engineers under the department. Now, if such is the stand, comma, it appears that the direct recruits or graduate engineers are not occupying the post of senior grade bracket functional in excess of their quota. To stop. It is, however, stated at the bar that after the filing of the writ petition, two more vacancies have occurred in the senior grade of the MES bracket functional. Stop. However, there are no materials placed before this court to appreciate that more vacancies have occurred during the pendency of the writ petition. First off, be that as it may, the rules of 2017 clearly stipulates that 80% of the posts are to be filled up by graduate engineers, while 20% of the posts are to be filled up by non-graduate engineers. Please read the last line.
The rules of 2017 clearly stipulates that 80% of the posts are to be filled up by graduate engineers, while 20% of the posts are to be filled up by non-graduate engineers.
First off, the state respondents at paragraph 10 of the counter affidavit have admitted that the two vacant posts of senior grade MES bracket electrical have been filled up as per the service rules and as per the standing instruction of the government. To stop. In other words, the state respondents have admitted to the fact that the two vacancies which occurred at the relevant time had been filled up by transfer and posting the respondent numbers 4 and 5 to the vacancies which otherwise was meant for non-graduate engineers as per the rules of 2017. Stop. The explanation given is that vacancy-based roster has prevailed over the post-based roster. As provided by the Office Memorandum dated 9/8/2021. So it may, however, be noticed that the rules of 2017 have been framed in exercise of the powers conferred by Article 3, conferred by the proviso to Article 309 of the Constitution, whereas the Office Memorandum dated 9/8/2021 is only an executive instruction. Next para. This code in WPC number 63 of 2019 had the occasion to deal with a similar and identical issue, except for that the matter was pertaining to the Public Health Engineering Department. Of this court, upon taking into consideration Rule 22 bracket 5 of the rules of 2017, including the provisos provided in the given facts of that case, came to a finding that the quota system between the graduate and non-graduate engineers existed as on that date, and therefore the two vacancies in the functional post of senior grade of the MES, being the quota meant for diploma engineers, the private respondents would not have been placed against the functional post. Accordingly, the placement of the private respondent numbers 5 and 6, who were graduate engineers, to the functional post of senior grade in the service was set aside. Mr. Zoram Chana, what is the quota? The quota exists in this case also?
My lord, exactly. That, my lord,
Because of that proviso, because we are referring
My
to that
lord.
proviso.
Yes.
This will continue so long as that.
So long as the officer were already there in the service at the time when this rule come into force were still there, my lord. Unless they
Either get
pen-
promoted or
died on superannuation, so and so on. As long as they are there, this quota system will survive. But this will have to be done away with the moment when all the incumbent officers have gone on superannuation, so and so on.
Have you made that statement anywhere?
My lord.
Where is that?
Kindly bear with me, Lordship. I met that. Para 13, my lord. 13, para 13, page number 8, my lord, of my petition.
What is the reply to that?
That it, it is also admitted, my lord, by the state, because this is the facts on ground, my lord.
Next para, in the present case as well, the quota system still exists, as can be seen from the amendments made in paragraph 13 of the number 13 of the writ petition, and also paragraph 7 of the counter affidavit filed by the official respondents. Stop. Such being the case, the impute notifications dated 5/4/2023 and 28/4/2023, insofar as the respondent numbers 4 and 5 are concerned, are found to be not sustainable and are accordingly set aside. Stop. The state respondents shall, within a period of 4 weeks from the date of receipt of a certified copy of this order, consider the case of the petitioners, along with all other eligible diploma engineers, bracket if any, as on the date when the private respondent numbers 5 and 6 were considered for their placement. Not 5 and 6, 4 and 5.
4 and 5, my lord.
4 and 5 instead, not
4
5 and 6. Placement. Considered for their placement, promotion in the functional post of senior grade of the MES under the P&E department in terms of Rule 22 bracket 5 bracket small a of the Rules of 2017. Stop. On such consideration, if the petitioners are found eligible to be promoted or to be placed in the functional post, the same shall be done without delay.
And if I may, Lordship, with retrospective effect, my lord, to take effect from the date as on when the private respondents were promoted.
And consequential benefits, as may be entitled to them in law, should also follow. Stop. With the above observation and direction, the writ petition stands disposed of. Then one more line. Since the present case is found to be squarely covered by WPC number 63 of 2019 and also by WPC numbers 63 of 2020, further time is not being granted. Further time has not been granted to the learned government advocate as prayed for.
My lord, regarding if unless retrospective effect has been granted, my lord.
I already said, as per law, whatever is there.
My lord. Obliged. Deeply obliged.
The meeting. Just call the item, whatever it means.
Item number 15 for hearing.
May I seek your lordship's kind indulgence on behalf of my senior, Mr. Villaromel. My lord, as my senior is having an urgent medical appointment, if the matter may be taken up on another day, on a fixed day.
Any objection?
No, my lord. If the matter can be taken after vacation.
18th of October, my lord.
18 October.
If it may be possible.
Yes, my
Okay.
lord.
As prayed for by the parties, list the matter again on 18th of October 2024.
Yes, my lord.
Obliged.